Welcome back to The Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're taking a look at a recent California federal court decision which found that AR-15s and similar rifles are not protected by the Second Amendment. SB Tactical, the originator of the pistol stabilizing brace, set the bar for innovation and product development in the PDW pistol category. From the insanely popular SB-M4 to the adjustable SB-A3 and even kits for pump-action firearms, SB Tactical braces are available for a wide variety of firearm platforms in fixed, adjustable, and side-folding models. To get 15% off your legally transported and carried pistol braces, use the code TGC15 over at sb-tactical.com. Recently, a California federal court issued an opinion in which it found that California's Assault Weapons Act, also known as the AWCA, does not violate the Second Amendment. The AWCA was originally passed back in 1989 and made it a felony to manufacture assault weapons within the state of California or to possess, sell, transfer, or import such weapons into the state without a permit. At the time of its passage, the act included a list of specific firearms identified by their make and model. Since its initial enactment, the act has been modified several times. In 1999, it was amended to define a new class of restricted weapons according to their features rather than by the model. For example, having a detachable magazine and either a pistol grip that protrudes conspicuously beneath the action of the weapon, a thumbhole stock, a folding or telescoping stock, a grenade launcher or flare launcher, a flash suppressor, or a forward pistol grip. In 2016, that legislation was again amended to prevent individuals from using bullet buttons. The underlying lawsuit brought several challenges, including a facial challenge to the AWCA. For those unfamiliar with the term facial challenge, it's one that contends the law, as it stands on its own, is unconstitutional. This is different than an as-applied challenge, where the person suing is contending that the law is unconstitutional, but only in relation to them. Since the challenge is taking place in California, the court applied a two-step test spelled out by the Ninth Circuit that's to be used when a Second Amendment challenge is brought. Step 1 requires the court to ask whether the challenged law burdens conduct protected by the Second Amendment. If it does not, the analysis ends and the law is upheld. If it does, the court then proceeds to Step 2 and selects an appropriate level of scrutiny to apply to the law. Intermediate scrutiny has been the level that courts all around the country have been using. Remember, intermediate scrutiny is in between strict scrutiny and the rational basis tests. In order to be upheld, it requires that the challenge law must advance an important government interest by means that are substantially related to that interest. The court began its analysis by looking to Heller for the proposition that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes. In order to determine whether the law falls within the scope of the Second Amendment, the Ninth Circuit requires that the court ask whether the regulation is one of the presumptively lawful regulatory measures identified in Heller, or whether the record includes persuasive historical evidence establishing that the regulation at issue imposes prohibitions that fall outside the historical scope of the Second Amendment. I know it's a bit dense, but stick with me here. In this case, the Attorney General argued that assault rifles may be banned because they are like the M16, weapons that are most useful in military service, and that they are also not in common use for lawful purposes like self-defense.
Oh, come on!
The court concluded that semi-automatic rifles are essentially indistinguishable from M16s, which Heller noted could be banned pursuant to the long-standing prohibitions on dangerous and unusual weapons, and therefore need not reach the question of whether semi-automatic rifles are excluded from the Second Amendment because they are not in common use for lawful purposes like self-defense. It went on to discuss the Fourth Circuit's reasoning in Colby, where Maryland's assault weapons ban was challenged. Unlike the court in Colby, which used the question, are the banned assault weapons and large capacity magazines like M16 rifles weapons that are most useful in military service, and thus outside the ambit of the Second Amendment, this court determined that the proper question was, are the semi-automatic rifles at issue here, like the military's M16, a historically banned, dangerous, and unusual weapon? If so, the semi-automatic rifles are similarly outside of the scope of the Second Amendment. Court stated that it's undisputed that the M16 is outside the scope of the Second Amendment. Thus, if a weapon is essentially the same as the M16, it's not protected by the Second Amendment merely because gun manufacturers have given it a different model number and dubbed it a civilian rifle. As to whether the semi-automatic rifles at issue are like the M16, this court agreed with Colby's conclusion that AR-15 type rifles are like M16 rifles under any standard definition of the term being like, which was defined as having the same or nearly the same appearance, qualities, or characteristics. So according to them, if it looks the same, it must be the same. After a quick analysis of the characteristics of AR-15s and M16s, including the rate of fire, how soldiers are instructed to use M16s with semi-automatic fire to be more effective, parts compatibility between the two firearms, and shared features which are within the AWCA scope, the court concluded that plaintiffs presented no evidence to meaningfully distinguish the semi-automatic rifles at issue from the M16, which allowed the court to conclude that semi-automatic rifles within the AWCA scope are virtually indistinguishable from M16s and thus are not protected by the Second Amendment. Put another way, the AWCA does not burden conduct protected by the Second Amendment, according to the court. Based on the two-step analysis discussed earlier, the inquiry ends there. However, the court conducted an analysis under intermediate scrutiny anyway. In a separate order that was issued earlier in the case, the court found that the AWCA does not severely burden the core of the Second Amendment right because individuals remain free to choose any weapon that is not restricted by the AWCA or another state law, and that the AWCA leaves individuals with a myriad of options for self-defense, including the handgun, which is the quintessential self-defense weapon per Heller.
How can I make up my mind when I got so many tasty options?
The court also found that the AG's evidence showed that semi-automatic rifles controlled by the AWCA were a poor choice for self-defense, and that evidence presented by the plaintiffs showed that while individuals may sometimes purchase assault rifles for self-defense, it's not the primary purpose for doing so.
That just happened.
Thus, the analysis under intermediate scrutiny becomes whether the government has a substantial interest in promoting public safety and reducing gun violence, and does the AWCA fit reasonably in achieving that goal? According to the court, the answer to that question is yes. In determining the answer, the court compared the findings of Congress made during the passage of the federal assault weapons ban with that of the findings of the California legislature in enacting the AWCA, along with the California legislature's concern for the use of those firearms in mass shootings and increased casualty rates. Plaintiffs argued that none of the challenged features that bring a firearm within the scope of that law, pistol grips, non-fixed magazines, thumbhole stocks, folding or telescoping stocks, and flash suppressors, have any effect on the power of the projectile it discharges, and thus the trauma that the projectile causes on impact. The court retorted, finding that plaintiffs missed the point. The enumerated features increase the capabilities of semi-automatic rifles and thereby enhance their capacity for mass violence. As a result, the court determined that even under intermediate scrutiny, the law survives. Put simply, according to a California federal district court, the assault weapons ban in California stands, and AR-15s and similar rifles are not covered by the Second Amendment. Now, you're probably asking, but Adam, what happens next? Plaintiffs are left with several options, although the one they most likely will take will be an appeal to the Ninth Circuit to review the lower court's finding. And, as it's well known, the Ninth Circuit isn't exactly what one would call gun-friendly. That's it for this episode. If you learned anything from the show, help us out, hit that like button, make sure you share it around with your friends. Don't forget to get subscribed if you enjoyed the video. Consider supporting us via the links down in the video description. And as always, thanks for watching. Sorry, Izzy, this one's a little rough, including my microphone is falling. Man, this is just not going well.
Yep, it's over, but don't worry, you can click on the video up top to watch last week's show, and the one below that is the one that YouTube thinks you'll enjoy. Check them out and let me know what you think.